वेलकम दोस्तों, आप सभी का स्वागत है एलएलए के वेबिनार नंबर 9 में। तो ये जो हमारी ट्रेन चल पड़ी है, धीरे 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 आगे बढ़ रही है और उस सभी के साथ हम भी नई नई चीजें सीखते जा रहे हैं। और आज का टॉपिक बहुत ही इंटरेस्टिंग है और आज का टॉपिक रिलेट करता है हमारे देश की वन ऑफ द बिगेस्ट सर्विस इंडस्ट्रीज से, वो है आईटी इंडस्ट्रीज। तो आईटी इंडस्ट्री से रिलेटेड जो लेबर लॉज है उसके बारे में अक्सर लोगों का बहुत ज्यादा कंफ्यूजन रहता है। और अगर आप हमारे देश के एम्प्लॉयर्स की लिस्ट निकाल के देखें तो इस देश के जो सबसे बड़े एम्प्लॉयर्स हैं उसमें से टॉप 10 में से मेरे ख्याल में 7 या 8 आईटी कंपनीज ही है। आप विप्रो ले लीजिए, टीसीएस ले लीजिए, इन्फोसिस ले लीजिए, सारी बड़ी बड़ी आईटी कंपनीज जो लाखों में एम्प्लॉयज हायर करती है। तो ऐसे में आईटी कंपनीज के अराउंड क्या लेबर लॉज होते हैं, और इनफैक्ट अगर मैं हमारे छोटे से स्टार्टअप को भी समझे तो कहीं ना कहीं ये शायद आईटी से जुड़ा हुआ है। अब जुड़ा हुआ है कि है या नहीं, ये आज के वेबिनार में हम समझने की कोशिश करेंगे। तो आज वेबिनार में हम समझेंगे भाई आईटी में आखिर कौन कौन से लेबर लॉज लगते हैं। आईटी में आपने देखा होगा कि बहुत घंटों तक लोग काम करते हैं, 12-15 घंटे तो रेगुलर होता है पूरे वीक में। तो क्या उन्होंने ओवर टाइम उनके ऊपर लगता है? मिनिमम वेजेस के क्या रूल्स हैं? आईटी कंपनी आपने देखा होगा हजारों एम्प्लॉय को हायर भी करती है और हजारों को फायर भी कर देती है। तो इस हायर और फायर की आईटी कंपनी में क्या स्पेशल पॉलिसी है, उनको क्या कुछ रिलैक्सेशन मिला हुआ है? इन सारे विषयों पर बात करेंगे। और आज हमारे साथ हैं अगेन अ वेरी वेरी प्रोमिनेंट नेम इन एम्प्लॉयमेंट लॉज एंड लेबर लॉज, जो ऑलरेडी हमारे साथ एक वेबिनार कर चुके हैं। जिस आपने देखा होगा कि एम्प्लॉयमेंट लॉज फॉर कंस्ट्रक्शन इंडस्ट्री पर हमने एक वेबिनार किया था। हमारे आज के स्पीकर का 30+ ईयर का एक्सपीरियंस है एम्प्लॉयमेंट लॉज में। आप पुणे से बिलोंग करते हैं। ऑल ओवर इंडिया कंपनीज को एज वेल एज गवर्नमेंट्स को आप कंसल्ट करते हैं एम्प्लॉयमेंट लॉज में। आपने इंडस्ट्रियल ट्रिब्यूनल, हाई कोर्ट, सुप्रीम कोर्ट तक अगेन केसेस को रिप्रेजेंट किया है। तो लेबर लॉज का, एम्प्लॉयमेंट लॉज का जाना पहचाना नाम, मैं मंच पर आवाज देता हूं मिस्टर जयंत शालिग्राम, एडवोकेट जयंत शालिग्राम। तो वेलकम सर।
नमस्कार, कैसे हैं आप?
सबको बस एकदम फर्स्ट क्लास।
सब अपने कलीग्स जो आज ज्वाइन हुए हैं, जो ये वीडियो देखेंगे, मेरी मन से उनको प्रार्थना है कि आजकल के ये डिफिकल्ट टाइम में एवरीबडी शुड बी सेफ एंड शुड बी टेकिंग केयर ऑफ सेल्फ एज वेल एज देयर फैमिली। इट इज वेरी इंपॉर्टेंट। आज का सब्जेक्ट आपने बहुत ही अच्छी तरह से चुना है। This is, it is amazing, and it is my pleasure to interact with you all.
थैंक यू सो मच सर। तो सबसे पहले मैं, जो भी मेंबर्स जुड़ चुके हैं, अगर आप आवाज आपको प्रॉपर आ रही है, आई गेस आ रही है सभी को, तो आप एक बार मुझे कमेंट करके बता दीजिए। और ये भी बता दीजिए कि इसमें जो हमारा फॉर्मेट रहेगा वो हमेशा रेगुलर फॉर्मेट रहेगा। जिस तरह से अभी सर आपको कुछ बेसिक समझाएंगे टॉपिक की, और आप अपने जैसे जैसे आपको क्वेश्चंस आते रहे वो आप ग्रुप पे चैट में शेयर करती जाइएगा। मैं वेबिनार के एंड में सर से वो क्वेश्चन क्लियर करने की कोशिश करूंगा। ऑल्सो जो ऑलरेडी कुछ क्वेश्चंस मेरे पास ग्रुप के थ्रू आ चुके हैं वो मैंने ऑलरेडी सर को फॉरवर्ड कर दिए हैं, तो हम वो भी कवर करेंगे। सर, नाउ स्टेज इज ऑल योर्स। आई एम गोइंग ऑफ द स्टेज। Thank you so much.
Thank you so much. It is always singular pleasure to actually interact with, not only you, but, also with all our colleagues and fraternity, members. This is tremendous. It is this आपके जो वेबिनार हुए हैं, इनको इतना बड़ा मतलब, response है. And this is actually, at a very convenient way of educating someone in the subject which probably someone is not well educated और उनको कोई जानकारी होनी है, तो just go to YouTube and subscribe to the the labor law channel. अपना चैनल में ये करेक्ट करोगे तो this is fantastic. This is
thank you so much, sir. Thank you so much.
This is really a startup, and this is, I can consider it as a startup, IT startup. It is very important. So what is IT? See, IT Act, Information Technology Act 2006, this is very important. That IT Act per se has nothing to do with the employees. IT Act actually controls the technology and the use of technology, and other labor laws as applicable to other industries. They are applicable to the IT employees as well. It is very relevant to note that who is a workman under the IT Act? Any technical person who is providing his services to the employer is a workman under the IT Act, under the employment laws, and therefore a person working in IT industry is also a workman. So all my colleagues should, obviously those who are working in IT industry and giving their services as HR in HR fraternity, helping the IT companies, they all know about this. So IT companies are covered under the various labor laws as any other company in India is covered under them, those laws. So for example, if we touch the first and fundamental provision of law, the Industrial Disputes Act. The Industrial Dispute Act is applicable to the industries which we all know, and accordingly, therefore, the provisions of the Industrial Disputes Act are applicable to the IT sector also. So all those establishments who are actually working in IT sector are covered under the various labor laws which are applicable to them. So Industrial Dispute Act, under the provisions of the Industrial Dispute Act, it may not be an industrial establishment, but it is an industry, and therefore the provisions of the Industrial Disputes Act are applicable. So what are the provisions of the Industrial Dispute Act? It defines who is employer, it defines who is workman, it defines how and when the provisions of the termination, retrenchment, closure, layoff, or lockout will come into play, and how they are required to be dealt with. It is relevant. It is. I would like to point out that any person who is, let us define the definition of a workman. Any person who is not employed in supervisory cadre and drawing salary or wages less than 10,000 rupees, less than 10,000 rupees, and a man he's also a workman. So for example, a supervisor drawing salary less than 10,000 rupees, he's a workman. But only those two categories. One is category a supervisor who is drawing wages or salary more than 10,000 rupees, and all managerial employees, all persons who are working in managerial category are not workmen. So the other way, any person who is working in technical category, for example, in BPOs or in IT or IT enabled services, the employees rendering their services, irrespective of the fact that how much wages or salary they draw, they are, according to me, doing technical responsibility. They are following their technical responsibilities. Some of them are programmers, some of them are providing various other services to their organizations, and therefore the people who are working in a technical cadre or following their responsibilities in a technical way, these are, according to me, are workmen, and therefore the provisions of the Industrial Disputes Act are applicable. So what does it mean? So for example, as you mentioned, at the beginning, that at the time of in thousands people are employed, and similarly thousands of people are terminated. So what is the responsibility of the employer when they are hiring the employees and when they are relieving the employees in whatever manner and way? So when they hire the employees, the contract of employment is very important and material. So that decides the designation, compensation to be paid to the employees, then the rights and responsibilities of the employees as well as the employer. For example, I'll give you two simple examples. The transfer of employee from one place to another.
सर एक छोटा सा रिक्वेस्ट है, थोड़ा सा आप अगर स्पीकर के पास आके बोलेंगे, थोड़ी वॉइस लो आ रही है. हाँ, थैंक यू सर, थैंक यू.
तो ट्रांसफर ऑफ एम्प्लॉइज, अभी ठीक है. Transfer is an incidence of service, and when transfer is not mentioned in the contract of employment, then the employer or a company has no right to transfer the services of employees from one place to another. When that right is not acquired in the contract of employment, as a matter of right, employer cannot actually transfer employee from one place to another. And when he has no right to transfer, and in such a case, if employee is transferred and he challenges that transfer, then when in absence of the right to transfer the employee, the transfer becomes illegal. Similarly, the issue in respect of the superannuation. So if the superannuation is not contractually decided, then there is no law in India which governs the superannuation. I'm not talking about the companies which are into public sector. because public sector companies are governed in the completely different by different rules and regulations. But in private sector, we're talking about only in private sector today. So those, I was talking about the superannuation age. So when superannuation age is not recorded or decided in the contract of employment, similarly like a transfer, one cannot enforce the superannuation. So there are certain high courts have ruled that when in absence of superannuation age, an employer has no right to superannuate the employee. This may sound a little absurd, but this is a fact. So that means an employee has a right to continue in the employment until he is fit to perform his responsibilities. So therefore, the contract of employment is very important and relevant. There are two more unique scenarios which are specifically in the IT sector, which are used is, these are non-compete and the bond type of situation which is agreed by the employer by the employees. So these two situations, non-compete and confidentiality and or sort of the other obligations which are created in the contract of employment, these are obligations which are created, governed and enforced only by virtue of contract of employment. So for example, if an employer mentions in the contract of employment that the person is not to be hired, or an employee once he is removed from his company, that he should not accept the employment with the competitor organization for a particular period of time. That is not so relevant, that is not so legally enforceable unless and until some payment is agreed to be paid to that employee for that particular period of no compete period, when an employer wants him not to join the competitor organization. So in absence of that, it is very, very irrelevant to enforce that clause. Now going forward, the confidentiality. A junior employee, if he is not exposed to the confidential information, an enforcement of such clause of confidentiality and binding him in different manner is also a difficult scenario. So generally, the object of non-compete, confidentiality and sort of bond situation, that employee will not leave the employment for a certain period of time, that is not legal. That is based on the contract of employment, the nature of responsibilities and the way the employee is performing responsibilities. So therefore, coming back to the Industrial Disputes Act, the situation is very, very volatile. Last 10, 15, 20 years, we have seen that this industry has developed. Earlier, we were depending on the farming. Then second, we started textile, then engineering. And now last 20 years, this industry has come up and grown. So unfortunately, the laws to adopt this change have not changed so far. We are still following. In fact, yesterday only, the Parliament has passed, the Rajya Sabha has passed 3 major labor amendments. About 20 labor acts are now consolidated in 4 different codes. We'll talk about it later on in some other time. This is not a topic at this of this webinar. But from 1947 until today, the evolvement of the labor laws is not as fast as the nature of industry has changed. And therefore, we have to follow the same old pattern like Industrial Dispute Act is Act of 1947. So the retrenchment or a closure or a layoff or a lockout in the respect or a termination of an employee is governed in this sector as if the employee is employed in the engineering or in any other sector. So what all the responsibility of the employer if they want to terminate the employees, then obviously it is a closure, then notice at least of 1 month's wages, notice of 1 month's period or wages in lieu of that is required to be provided, and compensation at the rate of 15 days salary for each completed year of service is mandatory. In absence of this mandatory payment, the termination becomes void and illegal. And there are innumerable examples, and there are practically every high court of India And in many cases, Supreme Court of India has also held that such termination, which is against the legal provision, is obviously bad in law, and the relief is reinstatement with full back wages and continuity of service. So then the question arises: then why there is no litigation in this particular sector? We have all seen, it is not only in India but across the globe. Why litigation is not there? Because when an employee is removed from one organization, he gets immediately employed in some other organization. So he has no time to actually litigate his unemployment, and therefore there is no practically litigation available in this particular sector. Now only, in the last couple of years or 3-4 years, I have seen that some unions and some employees are now actually ventilating their grievances through the machinery which is constituted under the employment jurisprudence in India. So Industrial Dispute Act is a fundamental provision which, according to me, is applicable to the provisions to this IT companies, and therefore, since IT companies are industries under the Industrial Disputes Act, the employees who are not supervisors and managers employed in these companies are workmen under the provisions of this law. Therefore, they have every right to ventilate their grievances through the channel under the Industrial Disputes Act. So going forward, your next question was whether, what sort of overtime, the working hours and other service conditions are governed of these employees. We are not talking about the senior employees like managers or supervisors. They are not workmen, so these provisions are not applicable to them. But let me clarify one important point here. IT companies earlier, the pattern was also in the IT sector, the pattern of work has also changed a lot. The hardware, those companies who are manufacturing hardware, they are definitely governed under the provisions of the Factories Act. We are not talking about them. We are only talking about only the companies engaged in software and IT enabled services. So these employees working in these organizations are governed. There is a dispute, and that dispute is pending before the Honorable Supreme Court of India as to whether the IT enabled services, companies providing these kind of services, whether they are factories under the Factories Act. See, there are two important concepts. Every establishment in India is either covered under the Shops and Commercial Establishment Act or under the Factories Act. There are some other legal entities like mines and oil fields and other things. We are not talking about that. But generally, these are the two. Establishment is either a factory or a commercial establishment or a shop. But we are not talking about shop as well. So commercial establishment, whether the IT company's office is a commercial establishment covered under the provisions of the Shops and Commercial Establishment Act of the respective states, or it is covered under the provisions of the Factories Act. These two questions are very important and relevant. At this point of time, the provisions of the Factories Act are not applicable because the issue as to whether the IT and IT enabled companies engaged into manufacturing or not, whether the data usage of data and transmission of data, whether it amounts to manufacturing or not, that is also a $1 million question. And that question, every movement, data is now, as we all know, data is actually, is a gold mine. So transmission of that data, usage of that data on machines, on computers, on laptops and iPads and, all sorts of gadgets, whether usage of that kind of thing, whether does it amount to manufacturing? So churning of data, does it amount to manufacturing is a question, and that question is posed before the Supreme Court of India, and Supreme Court has referred this issue to the larger bench, and that is pending for decision. So unless and until the issue of whether the IT companies are manufacturing companies, so that the provisions of the Factories Act are applicable or not, so that issue is yet to be decided, and therefore, according to my view, the provisions of the Shops and Commercial Establishment Act of the respective governments are covered and governing the service conditions of these employees who are working in IT companies. So what does it mean? So supervisors and managers are not eligible for overtime. But all other employees who work more than 8 hours a day and 48 hours in a week. See, this is very important. It is not that some day you work 10 hours, the other day you work 5 hours, and that makes the 48 hours a week, and therefore the condition is fulfilled. It is not that way. So 48 hours totally in a week and 8 hours in a day. So, for example, a person works 9 hours on 6 days, then he is eligible for overtime on each day of services he renders of the week. But if he renders less than 8 hours, then he is not eligible for that. So any amount of work which is performed more than 8 hours is eligible for overtime. But it is important to note that the overtime, it cannot be suo motu. Employee cannot decide that when and how he works overtime. It is required to be mandated, it is required to be ordered by the superior of the employee, and then only he is eligible for the overtime payment. So the conditions, the safety, security in the establishment, especially for a women employees, it is very, very important that large chunk of the employment in this sector consists of women employees, and their safety and their proper working conditions are governed under the provisions of these Act. It is essential and necessary that employer must provide all sorts of proper drinking water, canteen facility, medical facilities, and all sorts of basic fundamental situations to these employees so that their employment can become a very conducive to, and the work atmosphere becomes very healthy. So view is this, that employees, in short, we will cover one by one legal provisions, but to sum up the issue, whether the employees employed in IT sector, whether they are covered under the provisions of the various labor laws, the view and the settled legal position as of date is that all these labor laws which are applicable to the workmen are applicable to the employees working in the IT and IT-enabled companies, except the supervisors and managers. And therefore, the view is this, that all of these employees are eligible and they are entitled to claim the benefits. So, for example, now we cover the various legal provisions, in briefly. So, for example, the medical, if you take a medical issues. So, for all employees in an IT company who are employing, the IT company employing 20 and more employees, and if it is, in the area where the provisions of the ESI, Employee State Insurance Act, are applicable, then in that case, that the employees are governed under the provisions of the ESI Act, and therefore the provisions, the protection of all medical facilities as provided under the ESI Act are applicable to these employees. So they are entitled for all the medical benefits as well as all insurance benefits flowing from the ESI Act. Provident Fund Act. So we take Provident Fund Act is applicable subject to obviously it is the applicability of the act is subject to that particular threshold of the wage limit or salary limit. So Provident Fund, so far as the ESI is concerned, we discussed, ESI is concerned is 21,000. So all employees who are drawing gross wages less than 21,000 rupees a month, they are all covered under the provisions of the ESI Act. So going forward, Provident Fund Act, the employees are covered under the provisions of the Provident Fund Act, and all IT and IT-enabled companies are covered under the provisions of the Provident Fund Act. So the employees who are, the companies who are employing 20 and more employees are also covered under the provisions of the Provident Fund Act. So those employees who are not covered under the ESI Act, they are covered under the Employee Compensation Act. So any accident or medical emergency arising out of employment or during the course of employment, then those issues are covered under the provisions of either under the ESI Act and or under the provisions of the Employee Compensation Act. Maternity benefit, this is also a very relevant provision, and I see a lot of queries so far as this act is concerned. So Maternity Benefit Act is also applicable to the IT employees employed in the IT companies. We see a lot of benefits are provided by the IT companies also as a paternal leave and things like that. So, but then as a matter of right, female employees are eligible for maternity benefits and paid 6 months leave. So therefore, it is, and that is restricted to first two deliveries, and later on it is brought down to the marginal level. So this is, the maternity benefits are one of the best benefits across the world provided by the Indian government through the Maternity Benefit Act under the provisions of this for the female employees employed across the industries in India. So this is very important change which this government has brought up. Going forward, I have received a lot of queries whether the provisions of the Payment of Bonus Act are applicable to the employees or not. Yes, all employees, including managers, whose salary or wages is less than 21,000 are covered under the provisions of the Payment of Bonus Act. And as a matter of right, if the provisions of the Payment of Bonus Act are applicable, then the employees are eligible for the bonus every year. And especially those companies who are provided, who are working more than 5 years, all their employees, after rendering their minimum service of 30 days in a particular financial year for which the bonus is related, they are eligible for the bonus. So bonus is also applicable. Going forward now, there are a lot of project appointments are done by the companies. So whether these project appointees, whether they are covered under the legal provisions, yes. If the project employees are employed for certain project, then these employees are also covered under the provisions of these acts. Now, the change has been incorporated in the, it has been discussed also that whether the payment of gratuity, this is very important, that the payment of gratuity is applicable to the employees who have rendered less than 1 year, less than 5 years of service. Yes, the government has proposed a change in the Payment of Gratuity Act, and all those employees who are appointed on a project basis for each completed year of their project, even though that project appointment is less than 5 years, they are eligible proportionately for each year's gratuity. So this is a big change which has come. And these employees who are appointed on a project basis, they work on a project basis, they are covered under the provisions of the Payment of Gratuity Act, and they are eligible. For example, if Mr. A is appointed for 3 years period, and he, on completion of the project, he leaves that appointment. He had to leave that appointment. So he is eligible for the gratuity. So he is eligible for the payment of gratuity at the rate of 15 days for each completed year. That means he is eligible for 3 years service, 45 days of gratuity. It is very important that all these factors are required to be built in the costing when an employer employs the in any organization, especially in this particular organization. We have seen that cost to the organization. So what do you mean by cost to the organization? The cost to the organization means the cost of hiring the employee, how much employer is investing in that employee while he is hiring that employee. And that issue is very sensitive. So when you are factoring, so brothers and sisters, you are factoring, when you are hiring the employees, you have to factor all these costs into these particular, into the costing of when you are hiring the employees. So this is very important. So now going forward, I have seen a lot of companies have terminated the employees without following due process of law, especially in this pandemic period. Because when there is, the general understanding is that when there is no work, these employees are not essential and they can be removed anytime. This is not the fact. Now, especially on the background, the litigation is on an increasing scale, especially in the states of in the state like the NCR, National Capital Region, Maharashtra, Gujarat, Karnataka, Tamil Nadu. These are the states where the litigation in IT and IT enabled sector are now increasingly on a higher side. Why? Because the situation has changed and there is no alternative employment available, and therefore now employees are challenging their termination on the ground that they are illegally terminated. So appreciate this. Then what legal provisions you have to follow? Legal provisions are required to be followed when you are the payment of compensation is one, but in the event of retrenchment, you have to follow in a department-wide seniority list, and on a seniority basis, considering the seniority, last come first go, or a junior most employee should be removed first by following due process. That is required to be done. So it is very important that this particular industry, so any company in IT sector, is not considered as an industrial establishment. And therefore, for retrenchment, closure, or a termination, no government permission is essential and necessary. Only if it is a factory, if tomorrow the Honorable Supreme Court decides this industry as a factory, then the situation will be different. But as far as today's situation is concerned, for these kind of things, no employer requires a government permission, but they have to follow the due process of law. So we discussed the procedural law, we discussed the beneficial legislation, and we discussed the contractual obligations. So these are the important, this is, bundling together all these aspects. The rights and responsibilities of the employees are quite similar and quite, homogeneous to the rights and responsibilities of the employees who are working unemployed in any other sector. So my view that IT and IT companies are covered under the provisions of the various labor laws based on subject to the applicability and the ceiling provided under these different provisions of laws. So now I'm open for questions with this background.
Thank you so much, sir. Thank you so much. That was very enlightening. So overall, can we conclude that as of now, IT companies are governed as per Shop and Establishment Act, all the rules and regulations as per Shop and Establishment Act?
Absolutely. It is my view, and this has been confirmed in many judgments, that unless, for example, if you don't register your establishment under the Shop Act, suppose your industry is located in Delhi and Delhi Shop Act is not complied with, then it is not legal. You are employed in, you are registered in Mumbai Shop Act, Bombay Maharashtra Shop Act is not registered, it is illegal. So the provisions, the Shop Act governs the working hours, then the leaves, the provisions of leaves, the provisions of the, I have not touched one particular point, that the standing orders. So Rishabh, standing orders are very relevant and important. Some of the states, so for example, Tamil Nadu, Kerala, the Karnataka, have not made applicable the provisions of the model standing orders of the respective states to the employees employed in the IT sector. But that is not the case in Maharashtra. So any establishment, even if it is an IT organization, IT company, employing 50 and more employees, then the provisions of the model standing orders will be applicable, unless that company has their own certified standing orders. So that is another factor. So this is, generally the pattern is followed by the IT companies. Maybe a very modern sort of a pattern, that a very flowery contract, the appointment orders are provided and, things like that. But then, I have seen that certain basic fundamental things are missing from those appointment orders. So it is essential and necessary. So you may have, see, for example, I give an example that a certain person who is employed in a very confidential, who handles a very confidential information in an organization. And there is a cutthroat competition going on in this sector. So it is like a Pepsi Cola and Coca-Cola company. It is like a, two enemies are fighting like, rats. So when in that case, if there are ways and means, let me explain you. As per the provisions of the General Clauses Act, there are certain contracts which are non-enforceable. I underline the word non-enforceable. Contract of employment, of individual employment, is one of them, and it cannot be enforced. So an employee will not leave the employment for a certain period of time. Such clause is totally void. There is no way one can enforce this clause. So under the provisions of the General Clauses Act, the contract of individual employment is non-enforceable, and therefore such clause in the appointment, even if it is agreed by the employer and employees, it is non-enforceable. So you cannot go to the court and say that, yes, this guy is, sitting on a big, sensitive and important information, and he should not be, he should not leave the employment. That is not legal. And so, this is where the difficulties come. A lot of companies whose managers or whose owners coming from a Western idea, where the laissez-faire economy is in progress and hire and fire is possible. This is not the case in India, even in this sector. You have to follow the due process of law, and the obligation, which are void obligations, we all know. My brothers and sisters who are here today, they will certainly appreciate that anything which is contrary to the legal provision is non-enforceable under the law, and it cannot be enforced even if both the parties agree to that. So these kind of things are not enforceable.
Okay.
But there are ways and means. So there are ways and means. So for example, when you decide a compensation of an employee, or you promote that employee and give something extra as a compensation to that employee, then if you feel that such person should not leave the employment for a certain period of time, then you can pay that amount and built in that cost in his regular routine payment. So for example, someone is paid say by say for example 50,000 rupees, and he is promoted, and after promotion his compensation goes up to say 1 lakh rupees. Then maybe 10,000 rupees if are paid for he accepting not to leave the employment for a certain period, that may be justifiable and that can be enforceable in a very. So this is a very tailor-made situation, and very few, and very few people appreciate this, because they have seen it that this is where the companies have failed in enforcing the contractual obligations, because they are not in consonance with the legal provisions prevailing in India.
Okay. Sir, in IT companies, this situation is very common. Like, nobody wants to hire fresher, but everyone wants to hire 2, 3, 4 year experienced guy. So the companies who hire fresher, they diligently work on their training, development, teaching them various software languages and etc. And then when they learn everything, they leave the job. So how IT companies can prevent that?
So exactly. So, maybe, for a first year or 6 months or, whatever time, it is very important that this investment should not go waste. So this kind of a situation to prevent, any company is not a training institute where, they train and then the employee acquires some kind of a skill and then they leave and then they get a job in somewhere, some good organization. This should not. So when contract of employment someone is drafting, there you have to pinpoint this issue, that company is, directly or indirectly, there are certain trainings which are online. When employee is employed, he's drawing salary or wages, he still gets some training.
Right.
So this kind of a cost can be built, and then you can make employee accept that this is the cost, and if you leave this kind of, if you leave within this particular period of time, then you are liable to reimburse this cost. But that is required to be quantified, and that is required to be justified in proper and legal and the practical manner.
Got it. Now, sir, let's come to this overall IT definition. Which kind of companies we can consider IT companies? And there is an act called IT Act, I guess. So how does that impact labor laws?
Actually, that there is nothing, that IT Act has nothing to do with the labor laws. IT Act defines what is an information technology. The definition of information technology is provided in the IT Act, and it is, the all credit for this IT Act goes to late Mr. Pramod Mahajan, who was the first the minister of this particular department, and he brought that particular provision of law into law books. It is very, very, we have to salute him, for his vision, for his, forecasting. So this particular, we see that a lot of cyber crimes are now happening. So how these cyber crimes are protected, what amounts to cyber crime, what amounts to information technology, and therefore this is governed and covered under the provisions of the IT Act. So IT Act has nothing to do with the employment rules and laws. Employment rules and laws are governed under the provisions of the acts which we have discussed. So there is a vertical split, that IT Act is, this is applicable to the technology, and the labor laws are applicable to the employees who are working in the IT companies.
Okay, sir. There is a culture of now business process outsourcing, BPOs, which are sprawling across India, and even they are getting work from outside India. Are they covered under this overall IT scenario, and does rules apply to them as well?
Yes, very much. These BPOs are also governed under the provisions of this law, and they being an employee, they fit into the definition of a workman, because they are, they're doing some technical job. They're talking to someone. They're providing services to someone. So these are the employees who are covered under the provisions. So even the BPO employees, according to my view, are workmen. They're covered under the Industrial Disputes Act. And the BPOs, business process outsourcing companies, are establishment, are industries under the Industrial Dispute Act. So the provisions of the ID Act will apply, and therefore the other peripheral acts like we discussed, beneficial legislations, the other procedural legislations are applicable to these companies and the employees employed in these organizations.
Okay. So one very technical question, I guess. What does these rule bend a bit for SEZ? There are IT parks in Bangalore, in Hyderabad.
So
Does
special
these rule
economic zone, this is very interesting question. There is nothing which is exempted under in SEZ. Special economic zones are created for specially, for special kind of industries, and especially for the industries who are produces, I mean, the manufacturing or providing services, basically for export purpose. So these special economic zones are governed under the different, and this is basically for the economic development and promotion of economic promotion. But labor laws relaxation is not available to these establishments which are located in SEZ and the employees employed in this particular. It is only one thing is different, that there is a kind of a there is one window channel which is available to the employer and employees to ventilate their grievances. But there is nothing different. There is no relaxation so far as the establishments are concerned, so far as the employees are concerned.
Okay, sir. Thank you. Now a question is coming. If a company like Infosys, they hire employees on their role and then send them to various banks or state governments to work in their respective departments as programmers, developers, essentially they are paying the salary, and these companies or these governments are paying Infosys. So now, number one, which act like professional tax, labor welfare fund, of which state will apply on these, because they are getting salary from say Bangalore, but they are employed in Rajasthan or Maharashtra? And number second, since these employees are even though on payroll of Infosys, but are directly working in supervision of the respective other company, so will they attract? Can they get permanency and other things?
Very interesting question, Bishop. This is a very complex situation has been developed, because of the nature of service. The service provider is required to depute their workforce, their manpower at the end user. Say we see, for example, let me give you an example that, the TCS is working for many banks, or even the Infosys is working for many banks and many government organizations. So their employees are deputed in these organizations. So they are the contractors. And the government where they are employed, say for example, in HDFC Bank, Infosys people are employed and they are working through the HDFC Bank premises. Then in that case, the HDFC Bank is a principal employer, and Infosys or a TCS, the IT company deploying these workforce there, is considered as a contractor. So this principal employer and contractor relationship comes into play. So to decide whether, there are many times that relationship is genuine, but sometimes it is bogus. So in that case, there are three to formula is provided of three test formula is provided by the Supreme Court. Recently, Justice Rohinton Nariman has delivered a judgment, and that judgment, through this judgment, the test is triple test. One is who employs, second is who pays, and third is who manages. So if all three answers is, say for example, in this case you have asked that if an IT company, then the IT company is employer. But if anything is difficult and answer is different than this, then the principal employer can come into play. And therefore the issue is whether the deployment, the appointment and deployment of employment is very important and relevant. And that is required to be done in the way known by the legal provisions. So if employees, say for example, there are very few employees who are working on some project. I see that, there is, the computers and, the systems are working everywhere now. There is no, even the farmers are using the technology. So to support the IT support is essential and necessary, and to provide that support. If the technology company is recruiting employees, then it is their responsibility to take care of these employees.
Okay. So, sir, just with for that example, companies like BSNL, they employs a lot of outsourced employee for data entry. I have personally known various employees working for 10, 15 years as data entry operator on contractors role, and they are essentially being managed by BSNL or some government organization. Can they claim permanency with them? Because
this is very interesting question, Rishabh. We are talking for the employers here. We are talking for the actually managers, HR managers who are actually part of this particular your series. But
right.
to answer your question, the largest principal employer in India is the central government and various state governments.
Okay.
There is, you see the contractors and contractors employees employed at various places. Lakhs and lakhs employees are employed in these organizations, which are owned, controlled, managed, supervised by the government. Like the one which you have mentioned, BSNL or MTNL, whatever, you can. Even you see the corporations, the various municipal corporations are employing a lot of contract employees for every and anything. So, for example, now you see the COVID hospitals are run on a contract basis.
Right.
So you see this, the biggest, largest principal employer in India is the government. Maybe it is central, state, or local government. So in that case, the rules, according to my view and my feeling, that this new code, the one which is passed yesterday in the Rajya Sabha, that provides for equal work for equal wages.
Okay. Okay.
This is very important, but that it is nothing new in that. Even the Contract Labor Regulation and Abolition Act provides for that. So your way, that permanency, if the perennial nature of activity is provided, is done by the contractor, then in that case, how legal it is. If it is not that legal, then such kind of the arrangement, it may not sustain and it may not survive.
Thank you, sir. That was just a theoretical question to clear the concept.
But then this is opening a Pandora's box. This is very
right, right. So let's just stop this, I guess, Pandora box. Again, one question which ITHR has asked, that someone is they are employing their staff to some other company because it's a very technical nature of job. Do they need to get this contractor license? Because I guess contractor license is not applicable for this technical service related jobs.
No, that is a misconception, according to me. That the contractor, if the technical company is deploying their manpower and these people are working out of that particular company's premises, the principal employer's premises, and the rules are different in different states. I don't know which state this question is coming from, but in many recent amendments, through the recent amendments, if there are less than 50 employees are deployed by the contractor at the principal employer's premises, then contractor has to do nothing.
Okay.
So the license, that, we have covered that Contract Labor Act. So the principal employer, if employing more than 50 employees either through one or more contractor, then the principal employer is required to register himself under the Contract Labor Act. Right. Similarly, if the contractor, like you said, this technical company, by virtue of their nature of work, is deploying manpower in the principal employer's premises,
right,
then if the number is more than 50, then in that case, that company is required to apply for a license under the CLARA, Contract Labor Regulation Abolition Act. But if the number is less, then it is not necessary.
Not necessary. Okay, sir.
But the first number is that threshold. Let me come. That threshold is 20 in some states and 50 in some states. So even if for example, going back to your the example which you have given, we discussed about a few minutes back, that BSNL. Suppose a company is providing the employees more than at one location, more than 50 employees, then that company, the principal employer as BSNL from the central government, is required to apply for a registration under the contract labor, and the contractor who is providing 50 and more workmen is required to take license under the contract labor act.
Got it, sir. Now the first part of this question: on which states professional tax labor welfare fund will apply on these employees?
This is a very fundamental. We have to go to the genesis of these two legal provisions. These two legal provisions are meant. They are basically state-oriented legal provisions. And when these state-oriented legal provisions are there, if, say, for example, an IT company whose head office is in Bangalore and deploying manpower in Rajasthan, in that case, it is futile to pay their profession tax or a labor welfare fund in the state of Karnataka. It is the place of work is more relevant than where the wages are drawn.
Okay.
So my view, and it is legal view, that where the employee is employing the services, the employee is rendering the services, there the labor welfare fund or the profession tax of that state
must be paid. Okay, sir. One question is coming. In many cases, we have to ask our employee to work on weekends like Saturday, Sunday. In that case, what will be the rules of overtime, and should we give compensation of what should we do?
Yes, if the working on a if it is a freak event of some on a particular day it is required to be work on a weekly off day, then compensation of the provision as provided under the Shop Act will be applicable. If the working hours are more than 48 hours in a week, then the overtime is eligible, and that person will definitely be eligible for the overtime payment, who is rendering services more than 48 hours.
Okay. Gurswak Singh is asking, is Bonus Act applicable on basic plus DA or on gross salary?
No. Mr. Singh, Bonus Act is applicable only on basic and dearness allowance, or a special allowance, as you may call it. It is not on gross payment. So the calculation of bonus is done only on basic and special allowance.
And applicability also decided by basic and DA on?
Yes.
Okay.
For example, if the employee is getting 21,000 is the threshold under the Bonus Act now, amended Bonus Act. So if employees actual gross wages are say 30,000 rupees, and basic and special allowance, if it is 20,000, that employee is eligible for the bonus.
Okay. I guess there is one question which you have, I guess, already answered. Is it necessary for IT companies to take permission of closure? I guess not, right?
No, because they are not considered as industrial establishments. See, the moment it is decided these IT companies are factories under the Factories Act, then they will be covered under the definition of industrial establishment as provided under the Industrial Disputes Act, where Chapter 5B of that Act is applicable, for which the pre-permission is necessary for closure, retrenchment, or even layoff.
Okay. And last question is coming. I guess this is also you have answered. If we have employees in different state, which state act will apply of different state, or the place of our principal employment or head office?
No, it is not. See, the place of employment is important. And see, I'll give you an example. There are media companies. You know that you are also considered as a startup in media company. So
right.
If you media companies are having employees. So for example, now it is very interesting. This question, based on this question, let me amplify a bit. If you have a couple of minutes.
Sure, sir.
Yesterday's new code, which is passed by the Lok Sabha and Raj Sabha, and I hope that the Honorable President will obviously make it applicable as early as possible. The working journalist. Earlier, these working journalists, the journalists which were employed in this technical, the media companies, were not covered under the Working Journalist Act. And therefore, they were not covered under the Industrial Disputes Act. But those journalists, video journalists, and the technical people, the various journalists working in media companies, they are now covered under the provisions of the definition of a workman under the new code of the industrial relations. So it is beneficial for them. You see, lot of employees in this sector are removed during this pandemic period for last 6 months. Today, we are completing 6 months, exactly 6 months of the lockdown. 6 months back, this day, the Honorable Prime Minister has declared the lockdown.
Okay. 23rd
So we are
March.
completing, the 24th of March, the
24th
lockdown was
March,
declared, and
Right.
we are exactly 6 months down. We
Okay.
never knew this kind of situation have never arisen in our lifetime. But this has been done to protect our lives.
Right, sir.
But during this particular period, the businesses have gone down, the employment has gone down. And there was no, whether, unless you are a workman in this country, you have no protection of employment. So if you are a manager and a supervisor drawing wages more than 10,000 rupees, it is, you have no protection of law. So therefore, the technical companies who are, to answer back your query, technical companies are very, very, we need to know that these technical companies are very, very relevant, and these companies employing these people who are working for who are carrying out their technical responsibilities are workmen and covered under the various legal provisions.
Okay. So, last question.
If you allow me to complete. So this
Sure,
is,
sir.
yeah. So you see the wave of litigation, about in last 20-30 years, during the last 20-30 years of time, the wave of litigation was basically coming from the government organizations and basically the textile companies and the engineering companies. But now you see, I foresee it, that the wave of litigation between the employer and employee may come from this sector.
Okay.
And we all have to be ready to challenge that, to accept that challenge, and therefore be ready to be legally compliant to protect the rights of the employer, as well as to ensure that the employees get their due share of that. And therefore, it is essential that you comply these provisions of laws.
Okay. Sir, last one question I'm asking from the comments, it is, can we hire, if not all, most of our employees on contract basis? And is it okay if we pay them annual gratuity?
See, gratuity by law. See, unless the employees, if they are employing contractually, it is illegal. It is an unfair labor practice to employ an employee for a brief period so that he is deprived of his rights of permanency. That is an unfair labor practice. So if anyone is employing the employee for a brief period when the job is perennial or a permanent nature of job is there, so in that case it is an unfair labor practice. So having said this, the view is this, that if the employee, because of the Gratuity Act amendment, if the employee is employed on a project basis less than a period of 5 years, then he is eligible for the entire period of gratuity. Gratuity is not an annual payment. I have seen, the cost of company gratuity is also considered and it is paid monthly. That is correct. That is not a correct idea, because some payments are monthly payments, some payments are annual payments like bonus, and some payments are arising out of the length of your employment. So the object of gratuity is a kind of a pensionary benefit. And if that pensionary benefit object, if you are paying it on a monthly or a yearly basis, that is defeated. So the law says that it is at the end of the employment. So my view is that such intermittent payment of the liability is not correct. And that is the reason why you see all the gratuity insurance schemes are actually, they are, when the premium is paid, nothing of that premium is going back to the employer. Whenever the employees are eligible for that payment, they are paid out of that corpus, and nothing is going back to the employer. Once it is,
otherwise it lapses.
Otherwise it lapses.
Okay. Okay.
So to answer your question, it is not a correct idea.
Okay.
But,
thank you so much, sir.
But the employees employed in this sector, they see that there is also a demand from the employee that yes, whatever you are giving me, don't let it spill over by a month. You give me whatever you are whatever we are deciding. Give me now. End of the month, I want my paycheck. I don't want my gratuity. I don't want you give me now. I want my incentive. I want my bonus. I want my gratuity now. I don't want even provident fund.
Right.
But this is not legally correct idea.
थैंक यू सो मच सर, थैंक यू। एंड मतलब ये मतलब हम रेगुलरली देखते हैं कि आईटी इंडस्ट्रीज में कुछ ऐसी नई नई प्रैक्टिसेस आती है या ऐसे नए कंसेप्ट्स लेकर आते हैं, दे ऐड सो मेनी थिंग्स। इवन मैंने देखा है कि लीव को भी वो कॉस्ट टू कंपनी में जोड़ रहे हैं, ग्रेचुइटी को कॉस्ट टू कंपनी में जोड़ रहे हैं, ग्रेचुइटी का मंथली पेमेंट हो रहा है, बोनस का मंथली पेमेंट हो रहा है, नई नई तरह तरह की चीजें आती रहती है थैंक्स टू आईटी कंपनीज। कुछ लेबर लॉ कंसल्टेंट्स के लिए नए नए चैलेंज बनते रहते हैं।
No, in fact, this is arriving from a different part of the world where the concept of the socialistic pattern of labor laws is not applicable. So
Okay.
if suppose this the laissez-faire economy, suppose if these concepts are coming from the Western world, we have to request the labor laws advisors have to modify these things suitable to the Indian conditions and applicable to the Indian conditions.
Okay. Okay, sir. Thank you so much. That was very, very insightful. And there are still few questions, but I guess we have exceeded our time. No, sir. Is it okay if I take
Please
a couple of
go
more
ahead.
questions?
No worries. We want to satisfy all our viewers. Whatever their
Okay.
questions, to take them.
Sir, one question Adarsh is asking: when employee are paid minimum wages, which is about 10,000, are they still workmen? And can an employee with more than 10,000 wages can ever be called a workman?
See, after going through this particular, the entire our session, I think probably this question is already answered. And my friend, you said name Adarsh, na?
Yes.
Yeah. So
Yes.
he might get his he might.
So
he might
you, Adarsh, I guess you watched the session again. The first part is if minimum wage
but then-
itself is more than 10,000, then
No,
is it?
so the 10,000, the wages have nothing to do with the status of a person, whether he's a workman or not workman. Let me give you an
Okay.
example. The pilot of the airline, we see, many times you see that the airline, the pilot association, their demands are discussed with the Central Labor Commissioner.
Okay.
Why they are discussed with the Central Labor Commissioner? Because pilots per se are workmen under the Industrial
Okay.
Disputes Act. So
Okay.
any person who is doing skilled, unskilled, semi-skilled, or a technical responsibility is a workman. Only supervisor drawing wages 10,000 and above, and managers, there is no wage ceiling. They are not workmen. So the minimum wage and has nothing to do to decide whether, suppose in Maharashtra state, in the construction sector, masonry person doing masonry job, their minimum wages are about 17,000. Believe me. So the minimum wages are more than 17,000. So does he a workman or no? Yes, he's a workman.
He's a workman.
Minimum
Okay.
wage has nothing to do with to decide the status of a person whether he's a workman or not workman.
You actually have to see whether they are like managing people under them or not.
So that is very important. You have to lift the veil and see the responsibilities. What sort of responsibilities person is performing.
Got
Even
it.
those lawyers who have worked very hard in the trial court, they will definitely appreciate this, that in the employment jurisprudence, that it is very difficult when you take a plea that a person is not a workman, to prove that plea is extremely difficult.
Okay. I guess the pilot example sums up. That is perfect example for this case.
But contrary, the exact, this was the pilot was the one end of the line. The second end of the line, you have a shop. Okay, you have a shop and small, there are 5-10 people are working there, and to control their services, a manager is employed. That manager is not a workman. So this is the paradoxical situation.
Okay. That's not workmen because probably they are managing people.
They are managers and therefore they are not. So there are multiple factors which are relating to this.
Okay, sir. One question Mr. Saini is asking: principal employer is paying bonus at 20% and contractor is paying at 8.33%. Is it okay?
Yes and no. Why yes? Because contractor is independent establishment and the entitlement of the bonus of the employees of the contractor depends on the balance sheet of the contractor. If the balance, and why no? The balance sheet, if it is provides for more, more payment of bonus than 8.33%, then employees of the contractor are eligible for more percentage of the bonus.
Okay. Last, I guess now it's the last question.
Yeah.
Deepali is asking, in case of death, how much gratuity should we pay, 5 year or how much?
No, see, in case of a death, there is no 5-year ceiling is applicable. So even if the qualifying service is not deployed by the employee who unfortunately face this situation, then the gratuity is payable is full. In fact, if it is insured, many of the group gratuity, practically all group gratuity insurance provisions are providing, in case of such unforeseen, event, the payment of full gratuity as if the employee is employed until his retirement.
Okay.
But because unfortunately under the Gratuity Act, insurance is not compulsory. So where there is no insurance compulsory, the qualifying service restriction is not required to be followed.
So till the time he was employed, that for that particular years, the gratuity must be paid. Say 3 years,
so 2 years, 3 years, 1 year, whatever it may be.
Whatever it may be. I guess that's it. Sir, thank you so much for giving your time, and you are such a wonderful teacher to all of us, and everyone enjoys your session, and especially आप हम लोग के लिए time निकालते हैं. That's a very, very big deal. A person with your stature and your knowledge gives out time to all the small time members. That's a blessing.
No one is small, Rishabh. No one is small and no one is big. It's important to share the knowledge, and I really appreciate that those my colleagues who are I don't know their names, but through your media, those who are watching this, I am always available for them. Thank you very much for inviting me here, and it is always pleasure to talking to you, and through your media, all my colleagues in the fraternity.
Thank you so much, sir. Thank you so much for joining me.
Take care and all the very best.
Thank you, sir. तो मेंबर्स, आई गेस आज का वेबिनार मुझे तो बहुत इंटरेस्टिंग लगा, क्योंकि इतनी सारी नई चीजें थी जिनके बारे में बिल्कुल आइडिया नहीं था, और आप सभी ने भी शायद काफी सारी नई चीजें सीखी होगी, और हम स्पेशल शुक्रिया अदा करना चाहते हैं जयंत सर का कि उन्होंने टाइम दिया। आपके क्या कमेंट्स हैं, क्या फीडबैक है, आप नीचे जरूर हमें लिख के बताइएगा या ग्रुप में हमारे साथ शेयर करिएगा। और भी जितने भी पहले वेबिनार हैं, जयंत सर का कंस्ट्रक्शन वर्कर्स के लिए भी एक वेबिनार था, दैट इज ऑल्सो वेरी वेरी इंटरेस्टिंग। तो अगर आप उस इंडस्ट्री से बिलोंग करते हैं तो आप वो भी देख सकते हैं, और हम फ्यूचर में भी जरूर सर से रिक्वेस्ट करेंगे कि आपके लिए कुछ मजेदार वेबिनार्स लेकर आते रहें। और सैटरडे को हमारा एक और वेबिनार है जो इंडस्ट्रियल डिस्प्यूट एक्ट के ऊपर है, वो भी शाम को 5 से 6 एग्जैक्ट टाइमिंग में आपको शेयर कर दूंगा। तो आज के वेबिनार में इतना ही। चलिए, सभी अपना ध्यान रखिए, कोविड में अपने परिवार का ध्यान रखिए। जय हिंद,